Okay, it's live.
Good morning. Welcome to the 2022 California Mock Trial Finals. This is the championship trial. So with further delay, I turn it over to Justice Perrin.
Good morning. Before I make preliminary remarks, we'll formalize these proceedings by inviting the bailiff to call this proceeding to order.
The Superior Court of the State of California, County of Los Angeles, Department 1 is now in session. The Honorable Stephen Perrin presiding.
Thank you, Ms. Du. My opening remarks are suggested here, and they'll be brief and direct. First of all, I rarely congratulate lawyers on coming to a courtroom. That's not a place where laudatory phrases seem to happen. It's a battlefield, but it's done in a civilized, proper manner with rules that govern the civility between human beings engaged in one of the great accomplishments of humankind, and that is the resolution of disputes in a courtroom, not with clubs, not with guns, not with knives, but in a civilized, responsible way. And you have demonstrated by your presence here that you are active participants in that wonderful process that we call due. That is what we do in courts. And I welcome you to these proceedings. This will not be the last time you see me smile in these proceedings, but I look forward very much to hearing what you have to say. And again, congratulations to the teams, which unfortunately I can only refer to as number 11 and number 12. At the end of these proceedings, I hope I'll be privileged to learn each of you, and I look forward to now commencing these proceedings. To help myself and the attorney's scorers, will the prosecution team please state your name and roles?
Yes, Your Honor. Good morning, Your Honor. My name is Natalia Betzler, and I represent the people of the state of California.
Good morning, Your Honor. My name is Stella Cushing, and I also represent the people of the state of California.
Good morning, Your Honor. My name is Jack Knowles, and I represent the people of the state of California as well.
Good morning, Your Honor. My name is Benjamin Spears, and I too represent the people of the state of California. This morning, I will be arguing the pretrial motion on the people's behalf. Now, Your Honor, with the court's permission, may the witnesses for the people please introduce themselves.
Please.
Good morning, Your Honor. My name is Ryan Brogger, and today I will be portraying Deputy Sheriff Tony Garrett.
Good morning, Your Honor. My name is Finn Mallard, and today I will be portraying Angel Russell.
Good morning, Your Honor. My name is Gabrielle Bayer, and today I will be portraying Terry Edwards.
Good morning, Your Honor. My name is William Simonton, and today I will be portraying Dr. Charlie Dunn. Now, at this time, with the court's permission, may the clerk please introduce herself?
Thank you.
Good morning, Your Honor. My name is Sophie Acapo, and I will be serving as your courtroom clerk for the duration of this trial.
Okay, and remember, it's your responsibility to get me to do things right, okay?
Yes, Your Honor. I will be giving both visual and verbal warnings at 2 minutes, 1 minute, 30 seconds, and stop. Your Honor, at this time, with the court's permission, may our coach please introduce herself?
Please.
Good morning, Your Honor. Molly Aller-Khan, attorney coach for Team 12. And that concludes our introductions.
Thank you very much. May I ask that the defense team come to the screen and state your name and role?
We are Team 11's defense. Good morning, Your Honor. My name is Natalie Green. I use she, her pronouns, and I'll be presenting the pretrial motion on behalf of the defendant, Jamie Covey. At this time, may the trial counsel please introduce themselves?
Please.
Good morning, Your Honor. My name is Mana Hashimoto, and I use she, her pronouns, and I represent the defendant, Ms. Jamie Kobe.
Good morning, Your Honor. My name is Sky Krieger. I use she, her pronouns, and I represent the defendant, Ms. Jamie Kobe.
Good morning, Your Honor. My name is Malia Marinchek. I use she, her pronouns, and I represent the defendant, Jamie Kobe. At this time, may our witnesses please introduce themselves?
Please.
Good morning, Your Honor. My name is Adela Kellerman. I use she, they pronouns, and today I will be playing the role of Jamie Kobe.
Good morning, Your Honor. My name is Alejandra Zavala. I use she, her pronouns, and today I'll be playing the role of Frances Yazzie.
Good morning, Your Honor. My name is Chloe Fong. I use she, her pronouns, and today I'll be playing the role of Danny Emling.
Good morning, Your Honor. My name is Nico Schweigler. I use he, him pronouns, and today I'll be playing the role of Dr. Tyler Clay. At this time, may our bailiff please introduce herself?
Please.
Good morning, Your Honor. My name is Jasmine Liu. I use she, her pronouns, and today I'll be your bailiff. I have a copy of the mock trial rules of competition should you need them. At this time, may our unofficial timekeeper please introduce herself?
Yes.
Good morning, Your Honor. My name is Ella Steer. I use she, her pronouns, and today I will be the unofficial timekeeper. I will communicate with the timekeeper after the completion of each task during the trial. I will notify you of any time discrepancies of 15 seconds or more. At this time, may our substitutes please introduce themselves?
Indeed.
Good morning, Your Honor. My name is Drake Woodruff. I use they, them pronouns, and I'll be the substitute pretrial attorney in case of any technical difficulties.
Good morning, Your Honor. My name is Sophia Tran. I use she, her pronouns, and I will be the substitute trial lawyer in case of any technical difficulties.
Good morning, Your Honor. My name is Sasha O'Malley, and I use she, her pronouns. Today, I'll be the substitute for Jamie Kobe in the event of any technical difficulties.
Good morning, Your Honor. My name is Stella Nuryev. I use she, her pronouns, and today I'll be the substitute for Frances Yazzie in case of any technical difficulties.
Thank you. Does that conclude the introductions? Apparently so. I also addressed the bailiff. Your job is to protect me, so take care of me. I believe, have we concluded? Oh, here.
The defense has a couple of more introductions, Your Honor. Apologies.
Thank you, Ms. Marichek. There we go.
Good morning, Your Honor. My name is Evelyn Trong. I use she, her pronouns, and today I will be the substitute for Danny Emling in the case of any technical difficulties.
Good morning, Your Honor. My name is Scott Jacoby. I use he, him pronouns, and today I will be the substitute for Dr. Tyler Clay in the event of any technical difficulties.
Good morning, Your Honor. My name is Sally Meeks. I use she, her pronouns, and I will be your substitute bailiff in the case of any technical difficulties. At this time, may our attorney coaches please introduce themselves?
I welcome that.
Good morning, Your Honor. My name is Cliff Yin. I use he, him pronouns, and I'm one of the attorney coaches for Team 11. This concludes the introductions for Team 11. Thank you, Your Honor.
I welcome all of you to the courtroom. And I believe we're now ready to proceed to the instructions that the rules require that I read. I think probably all of you can recite them to me by rote. You must complete your presentations within the specified time limits. The clerk will signal you as your time for each section of the presentation begins to run out. When your total time for each section runs out, you will be stopped even if you've not finished. Attorneys must call 4 witnesses within the time limits. This is a bench trial. At the end of the trial, I will render a verdict of guilty or not guilty in relation to the charges brought. The teams will be rated based on the quality of their presentation, independent of my verdict. Barring unforeseen circumstances, no recesses will be called, and if for any reason a recess is necessary, team members will remain in their appropriate places and should have no contact with spectators or coaches. Remember that objections are limited to the California Mock Trial Simplified Rules of Evidence located in your case packet. Are there any questions? Hearing none, the pretrial arguments will commence. The court calls the matter of People versus Kobe. I have before me a motion to suppress, I believe it is. And will the parties identify themselves? Let me see, I have some additional comments. Both sides have 4 minutes to present their arguments. Defense will begin. I will interrupt to ask clarifying questions. Time spent answering my questions is not included in the 4-minute time limit. At the conclusion of your arguments, each side will be offered 2 minutes of rebuttal time. Remember that the rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. Is counsel for the defense ready to commence?
Yes, Your Honor.
Ms. Green, please, your comments.
Good morning, Your Honor. Again, Natalie Green on behalf of the defense. In October of 2020, Deputy Sheriff Tony Garrett used police resources for a friend, Eric Smith, and set up a video camera to monitor my client's property without a warrant. The camera was placed on a 10-foot pole and monitored my client's property for 6.5 months. In the case of Katz v. United States.
Well, before we get to cases,
yes.
What do you want me to do? Somebody just walked over, a cop goes to somebody and says, hey, help me out here. Is that pretty much what happened?
Well, Your Honor, the defense respectfully requests that you exclude Exhibit A in trial today because it was found on my client's property by violating her Fourth Amendment rights.
Okay.
What happened?
What particular right is it that you want me to protect? Just let me know. What area, what premise, what?
Yes, Your Honor, the defense is trying to exclude Exhibit A because it was found by the police intruding into an area where my client had a reasonable expectation. So we are trying to protect the protections that are afforded to the home by the Fourth Amendment.
Okay. Is there some particular phrase in the Fourth Amendment that says that can be done?
Yes, Your Honor, the Fourth Amendment protects against unreasonable searches and seizures on behalf of the police.
Okay, well, go ahead, please.
Thank you, Your Honor. We can look to the case of Katz v. United States, in which the Supreme Court limited police use of technology in warrantless searches. The court in Katz, the police attached an electronic listening device to the outside of a phone booth. The court determined that the Fourth Amendment protects a person who has shown, number one, a subjective expectation of privacy, and number two, if society views that expectation as reasonable. Now, as I've said, the defense respectfully requests that you exclude Exhibit A in trial today because it was found on my client's property by violating her Fourth Amendment rights. And the defense has two main reasons. Number one, my client reasonably expected the obstructed parts of her backyard to remain private. And number two, even if the police could survey this private area of my client's backyard, the camera on a 10-foot pole surveilling for 6.5 months clearly required a warrant. This is a permanent police presence.
Let me ask you this. The police essentially, I could paraphrase this, they just kind of walked up, knocked on the door, if the police did anything here, and said, hi, we're going to watch your property. See you later. Isn't that essentially what happened here?
No, Your Honor. What actually happened was that the police gave Eric Smith, which was my client's neighbor and also landlord, a camera and put it on a 10-foot pole to monitor my client's property for 6.5 months. My client was not aware that this would happen. However, once she was aware of the camera, she took steps to protect her backyard from outside observation. She, in fact, told Eric Smith to take the camera down.
Go ahead, please.
Thank you, Your Honor. Starting with my first point, my client reasonably expected the obstructed parts of her backyard to remain private. Now, this is the northwest corner of my client's backyard where Exhibit A, the snake tongs, were found. We can look to the case of Kylo v. US, in which police used thermal imaging devices to sense heat from outside of Kylo's home from lamps that were used in illegally grown cannabis. The court found that this was a violation of Kylo's Fourth Amendment rights because it intruded in an area where he had a reasonable expectation of privacy.
You've just mentioned a magic word to me now here, privacy. Is that what we're talking about?
Yes, Your Honor.
Okay, where's that in the Constitution?
Well, Your Honor, privacy is protected in multiple ways in the Constitution. However, with the Fourth Amendment, the Fourth Amendment protects people, their property, and their papers from unreasonable searches and seizures on behalf of police, thus protecting their privacy there.
So the word privacy doesn't appear in the Constitution.
Not necessarily, Your Honor. However, we can look to the Fourth Amendment that shows us that citizens have a privacy when it comes to their persons and homes and papers against these unreasonable searches on behalf of the police.
Okay, go ahead, please.
Thank you, Your Honor. My client showed her expectation of privacy in multiple ways, her subjective expectation.
2 minutes.
Number one, she put the snake tongs in the northwest corner of her backyard, which was not available to the public eye. Number two, she testified that she expected this area to remain private. And number three, she told Eric Smith to take the camera down. And this expectation is reasonable because there is a 6-foot fence surrounding my client's backyard, and backyards are curtilage to the home and therefore afforded the same Fourth Amendment protections as the home. Now, moving on to my second point, my client reasonably expected the obstructed parts of her even if the police could survey this private portion of my client's backyard, the camera on a 10-foot pole monitoring for 6.5 months clearly required a warrant. This is a permanent police presence. We can look to the case of Schaefer v. City of Boulder, in which police gave Schaefer's neighbors a camera to monitor his backyard. The court found that this was a violation of Schaefer's Fourth Amendment rights and set a 2-part test, considering number one, the duration of the surveillance, and number two, the government's ability to collect information they could otherwise observe. Now, starting with the first part, this camera was monitoring my client's backyard for 6.5 months, much longer than the 56 days in Schaefer. And the second part of the test, the police could not have walked by and seen the evidence. The only way they could see Exhibit A was because the camera was on a 10-foot pole.
Let me ask you one last question.
Yes, Your Honor.
Supposing the neighbor got a box, stood on the box, looked over the fence and said, "Hey, Mr. Whoever, I'm going to watch you. I don't like you. You're bothering me and I want to see what you're doing." Is that any different than what happened here?
Well, Your Honor, if Eric Smith did indeed stand on a box to watch my client, it's unreasonable to say that they could stand on that box for 6.5 months without falling asleep. Your Honor, the duration makes this a very intrusive search. And for that reason, as we can look to the case of Schaefer, and we can also look to a binding case, if Your Honor would like. The case of United States v. Jones, in which police attached a tracker to the defendant's van and tracked the defendant for an extended period of time. And this was one of the reasons that this was considered a violation of Jones's Fourth Amendment rights, because of the duration. Your Honor, the 6.5 months was incredibly intrusive to my client's property because she had a reasonable expectation of privacy.
Thank you.
Thank you, Your Honor. This camera on a 10-foot pole monitoring for 6.5 months intruded on, it was a search that clearly required a warrant. Police wanted to perform this search, they should have obtained a warrant. And for these reasons, the defense respectfully requests that you exclude Exhibit A in trial today. Thank you.
Thank you. Does the prosecution wish to be heard?
Yes, Your Honor.
Mr. Spears, please proceed.
Once again, Benjamin Spears for the people. The defense's motion to exclude Exhibit A should be denied because the still photo of the defendant's snake tongs was not captured in violation of the defendant's Fourth Amendment rights for 2 reasons. First, the snake tongs were in the plain view of the public, pursuant to the 1986 U.S. Supreme Court case of California v. Cirola. And second, the defendant did not have a reasonable expectation of privacy under the 1967 U.S. Supreme Court case of Katz v. U.S. Now, first, Your Honor, let's look at plain view. Pursuant to Katz, if objects are visible to the public, then they have no Fourth Amendment protections. Now, the Supreme Court has defined a standard for the use of technology and surveillance in the 1983 U.S. Supreme Court case of U.S. v. Knotts. And here the Supreme Court established that if a device just serves a function that the police could have performed visually, then there's no warrant requirement. And applying this standard to the case at bar.
What were the facts in that case?
Yes, Your Honor. So in Knotts, the police placed a radio transmitter on the defendant's vehicle and tracked his car. Now, this was not a violation of the defendant's rights because they could have just followed the car and seen it with their naked eye. The radio transmitter was serving a process that just made visual observation easier. And the facts are the same in the case at bar. While there was a camera, a use of technology surveilling the area, it was just performing a function that the police could have performed visually because the snake tongues were visible to the public off public land.
Let me ask you this. You gave the example of this device attached to the car. In that case, did the defendant know that the device had been attached to the car?
No, Your Honor.
And when your police car is following somebody in public, does the defendant know that he is being followed?
He may or may not, depending on the nature of the sirens, but the issue in Knotts was that, and the way the people are analogizing it to the case at bar is the holding. And that's that when technology just makes a visual viewing process easier, visual observation easier, then we also have to consider the merits of the visual observation. And in the case at bar, the camera was just serving a process that the police could have performed visually. The camera is not necessary to perform the surveillance in the case at bar.
If I understand you, as technology increases, privacy decreases. You say this is just something that enabled the police standing wherever they were to see, view, hear, or otherwise know what is going on. That's pretty scary, isn't it?
Well, respectfully, Your Honor, no, because this area that we're talking about that the camera's surveilling has no Fourth Amendment protections because it's under the plain view exception. Your Honor, the plain view exception means that there's no warrant requirement to observe an area. So this camera really isn't new technology intruding into people's lives because it's doing something that the police could have done anytime because it's an area where the defendant has no reasonable expectation of privacy.
So that he builds a fence around his house, or she, and that doesn't evidence an expectation that within the confines of that fence, she is to be left alone. The police can't look over the fence unless it aided look over the fence. They can't hang, if they dropped a camera over the fence and landed it in her yard, that'd be okay. In fact, if they, as in the marijuana detection case, just were able by technology to pierce that visibility, an X-ray, something we're advancing to at this point, that's okay. Is that what you're telling me?
No, Your Honor. So we're not talking, the people aren't alleging that the entire backyard has no Fourth Amendment protections, but when we're looking at the exact area that the snake tongues were located in, Your Honor, that was visible to the public off public land. There's no reasonable expectation of privacy here. Here,
wasn't there a barrier between wherever the police would have been standing had they just not assisted and what they were looking at?
Your Honor, there was a 4-foot tall, unlocked, see-through chain link gate. So that's the only barrier protecting the observation off public land onto the snake tongues. Now, let's look at the 1986 U.S. Supreme Court case of California v. Cirola, where the police flew a plane over the defendant's 10-foot tall fence. Now, this was not a violation of the defendant's rights because the plane was in public airspace where the officers had a right to be. And therefore, there's no warrant requirement for the police to observe an area that they can see in an area of the right to be with their naked eye.
So you're telling me, if I understand this, nobody has any right to privacy within the confines of their curtilage, if that be the proper term. If somebody rents an airplane, please get in there and look over, get a helicopter and just hover over the property. It's open to view if you happen to be in a helicopter or an airplane, and that's okay?
Your Honor, the holding in the U.S. Supreme Court case of California v. Cirola was that the plane could fly over the property because the police were performing surveillance off public land with their naked eye. So that's what the US Supreme Court held, that observation is legal.
But
So
this is not public land. This is private land that they were looking at.
respectfully, Your Honor, no. Off public land, state park territory, you could see the snake tongues. Any member of the public has a right to be there, including Detective Tony Garrett.
Then I don't need the rule that says planes fly over can see things. They don't have to get a plane. If they can stand and look at it, game, set, match. That's it. There's no privacy.
Your Honor, there is no privacy in the case at bar because there's no expectation of privacy in the specific area that the snake tongues were located in, because any member of the public could see the area off state park land. And the holding in Ciarollo, and we apply it to the case at bar, is that if you're in public land where the officers have a right to be, looking at an area, then that observation is constitutional because you're not performing a surveillance. You don't need the plane. You can just use your naked eye to see the area. That's what the US Supreme Court held. Now, the defense has brought up a case that I believe Your Honor has suggested as well, the 2001 US Supreme Court case of Kylo v. US. And this was not in plain view because the police used a thermal imager to look through the defendant's walls. The thermal imager was performing a process that the police could not have performed visually. And this was a violation of the defendant's rights because it intruded into the defendant's home. And that's clearly distinguishable from the case at bar where you didn't need to intrude into the defendant's home to see the snake tongues. Anyone could see them. And comparing Kylo to the case at bar and back to Ciarollo, we see that the snake tongues are much more analogous. The observation that could have been conducted is much more analogous to Ciarollo. Now, the defense has brought up the fact that you would have to lean over the gate to see the tongues. But it doesn't mean that it no longer constitutes plain view. In the 1987 US Supreme Court case of US v. Dunn, the police walked onto the defendant's property, shined a flashlight through his locked gate, and that was not a violation because they never entered the barn. And in Ciarollo, the police intended to look into the defendant's backyard, so they flew a plane over it, and that was not a violation. And both of those actions, in those cases, are much more extreme than what would have had to happen in the case at bar to observe the snake tongues.
2 minutes.
And as a result, the snake tongues were in the plain view of the public, and there's no warrant requirement. Now, the second prong of the people's argument is that there was no reasonable expectation of privacy. And this relies on the 1967 seminal US Supreme Court case of Katz v. US, which defined a reasonable expectation of privacy as having a subjective belief and an objectively reasonable one. So first, let's look at objectively reasonable belief. As the people have already established, the snake tongues were in the plain view of the public. In addition, the defendant placed the snake tongues in an area that she knew the camera could see. How could any objectively reasonable person have believed that this area was private? Now, as we look at subjective expectation of privacy, we see that the defendant did not have this either because she waived it by acquiescing to the search. The defendant knew the camera was there for 7 months. Every time the defendant walked into her backyard, there was a sign that said, "Smile, you're on camera." Yet the defendant objected a single time and then forgot the camera was there. The defendant could have taken actions to conceal the area to keep private, like the defendant did in a case the defense has brought up, the 2012 Nevada District Court case of Schaefer v. City of Boulder, where the defendant raised her fence and sued the police. But in the case at bar, the defendant did not. The defendant could have taken...
I have to ask you here, what you're telling me, if I understand it, they could send a letter to the defendant, say, by the way, we're looking at your house, we're looking over your fence. If you object, send us a note back saying you don't want us to do that. And the burden then shifts to somebody to vindicate their own privacy rights, notwithstanding the police intrusion that they've just obtained. That's okay?
Well, Your Honor, in the case at bar, the defendant, yes, he objected a single time, but we have to consider the totality of the circumstances. We have to consider what happened after this objection. So the defendant realized, the defendant did not know that this was necessarily the police, and the defendant never objected to the police. The defendant objected to Eric Smith a single time. But for 7 months after that, the defendant forgot about it. And the defendant never moved the snake tongues inside, never covered the snake tongues, never blocked the fence or called the police even a single time. So a subjective belief, really, Your Honor, means that you believe the area is private. And considering the defendant's actions or lack thereof, we see that the defendant did not believe the area to be private because the defendant placed the snake tongs in view of the camera, never covered them, never moved them inside, never blocked the fence. The defendant did not believe this area was private. She effectively consented to the surveillance. She effectively consented to the viewing of the tongs and had no subjective expectation of privacy, Your Honor. Now, the defense has argued curtilage, but ultimately, Your Honor, curtilage is not a decisive issue in the case at bar. California v. Cirolo established that Fourth Amendment protections regarding the home are not absolute. But what is absolute, Your Honor, is plain view. The 1967 case of Katz U.S. establishes the plain view exception is a warrant exception. That means that regardless of curtilage, duration, intensity, or other factors that the defense has brought up, if the snake tongs were in the plain view of the public, there's no warrant requirement. And because they were, in addition to the fact that the defendant had no reasonable expectation of privacy, there's no warrant requirement and the defense's motion should be denied. Thank you.
Thank you. I'd hear from the defense as to your position, please.
Yes, Your Honor. Again, Natalie Green on behalf of the defense. Now, opposing counsel claims that the snake tongs were in plain view. However, this is untrue. We can look to page 11, lines 38 through 40, which say that the snake tongs were visible to anyone who could lean their head over the gate, thus trespassing onto my client's property. This is different than the case of Dunn because instead of shining a flashlight through a barn, the police would have to physically lean over and into my client's property. This would intrude into her property and constitute a search. And as to the case of Cirolo, there are many differences from today's case. This is the case of Cirolo is the one where the plane was flying over Cirolo's backyard. Number one, the plane was at an altitude of 1,000 feet, but in this case, the camera was on a 10-foot pole, thus getting a much clearer picture. Additionally, the plane flew over for one trip. However, in this case, the camera was there for 6.5 months. And number three, the case of Cirolo was in 1986 when camera technology was not as improved as it is today. Now going to my second point in rebuttal, my client showed her subjective expectation of privacy. Opposing counsel claims she did nothing to protect her property once she was made aware of the camera. However, this is untrue. She told Eric Smith to take the camera down. Additionally, it's unreasonable that my client would make significant changes to her property because she was a tenant. Saying that the burden is on her to protect herself from unconstitutional searches is saying that tenants have less Fourth Amendment protections than landlords. Your Honor, the police should not be able to tell a citizen they are violating their Fourth Amendment rights and then do so legally. The camera was on a 10-foot pole and monitoring for 6.5 months into an area where my client had a reasonable expectation of privacy. For these reasons, the defense requests that you exclude Exhibit A and trial today. Thank you.
Does the prosecution wish to be heard in rebuttal?
Yes, Your Honor. May I proceed?
You may.
So first, let's look at the defense's argument that leaning your head over the gate would be trespass. Now, this is factually false. All you would have to do is stand on public land and lean your head over this gate. That's not trespassing. In addition, it's not the only observation that could have been conducted to see the snake tongs. Anyone, Detective Tony Garrett, could have climbed a ladder and looked over the fence and seen the tongs, or stood on Eric Smith's property, on his house, on top of his roof and seen the tongs as well. So none of these cases are trespass. In addition, leaning your head over the gate does not mean that it's not in plain view, because in Dunn, it ruled that when you don't enter the property and you can see the area, that there's no Fourth Amendment protections over that area. Now, the defense has attempted to distinguish Cirolo from the case at bar with the duration of it, but that's not the analogy the people are comparing Cirolo to the case at bar with. Pursuant to Knotts, we have to consider all forms of visual observation that had to have been conducted to obtain the evidence. And when we're looking at Exhibit A, which is a one-time photograph, that we have to consider the fact that all it would have took was Detective Tony Garrett standing on public land a single time and looking through this gate. And when we're comparing that to flying a plane over a property, we see that they are very analogous. Now, the defense has brought up the issue that subjective expectation of privacy does not apply because the defendant was a tenant. And the people aren't suggesting that the defendant had to have taken the same actions as the defendant did in Schaefer. the defendant didn't have to sue the police. That may not have been available to her. But the defendant had to do something, And she did not. She never moved the snake tongs inside. She never even called the police one time. Your Honor, that's not a subjective expectation of privacy. She did not believe the area was private. So because the defendant placed the snake tongs in the plain view of the public, falling under the warrant exception, because the defendant had no subjective expectation of privacy, and because this belief was not objectively reasonable, there was no warrant requirement, and the defense's motion should be denied. Thank you.
Thank you, counsel. We are in this case confronted with a problem. The advent of technologies and the ability to compromise what would otherwise be reasonable expectations of privacy, as I understand the prosecution's argument, is subject to the advances of technology and diminish proportionally to those advances. I don't think the Constitution contemplated that. I don't think the Constitution contemplated that the average citizen has to be constantly on the alert for the technological advances that are made in society that invade what one would call normal expectation of privacy. And the burden should be on the state. And indeed, the Constitution sees that and has a proviso that says, if you want to search it, get a warrant. I'm of the opinion this activity constituted by any measure, police activity that should not be tolerated in a civilized society. And the motion to suppress is granted. No reference will be made to the tongs in the course of these proceedings. Thank you, counsel, and thank you for an excellent job. We turn now to the prosecution of the case. I believe the case is with the prosecution. Am I to inquire if there are any stipulations or other activities that need be accomplished at this point before we proceed to opening statement?
Your Honor, the people have a few preliminary matters we would like to address with the court's permission.
Indeed.
First, the state has brought exhibits A through E to trial. We've marked them for identification purposes only at this time. According to our rules, we've constructively shown these exhibits to the defense in advance of today.
And at this point, does that make them in evidence at this point, or you'll have to move them into evidence at the appropriate time?
We will need to move them into evidence. Until then, we will constructively refer to them, Your Honor.
Thank you. Anything else? Go ahead, please.
Yes, Your Honor. We'd also like to note to the court that pursuant to stipulations 9 and 10, all witnesses that know the defendant are assumed to have correctly identified her, and the people's witness, Angel Russell, can identify her as well.
Thank you. Anything further?
With that, Your Honor, the people are ready to proceed.
And any preliminary comments by the defense?
Yes, Your Honor, I believe that it has been exhibits B through E, according to the pretrial motion, that will be presented to be moved into evidence today in this trial. And additionally, we have two other preliminary matters from the defense. Firstly, we would like to say that because we cannot screen share exhibits, we ask that witnesses have a copy of the case packet and exhibits readily available to refer to. And second, we ask that the reading of the 27 stipulations found on pages 14 to 16 be waived but entered into the record as if they have been read.
Anything further?
No further preliminary matters from the defense, Your Honor.
I accept your offer that I not have to read 27 stipulations. I thank you very much. Is there anything further before I invite opening statement?
Nothing further from the defense.
Is the prosecution ready to proceed?
Yes, Your Honor.
Ms. Belzer, please. It's Belzer, is that correct?
Yes, Your Honor. My co-counsel, Stella Cushing, will be giving the opening statement for the people.
People may proceed.
On April 22nd, 2021, Eric Smith, the defendant's landlord, shut off the electricity to the defendant's home, knowing her disabled mother relied on that electricity to stay alive. Eric Smith killed the defendant's mother, and a week later, he was dead when he reached into his mailbox and was bit by a deadly Mojave rattlesnake, a snake placed there by the defendant. Eric Smith killed the defendant's mother, so the defendant killed Eric Smith. An eye for an eye, a life for a life. because the defendant wanted vengeance, and Your Honor, that's exactly what she got. That is why the people of the state of California have charged the defendant with first-degree murder and, in the alternative, voluntary manslaughter. Today, we must prove that the defendant intentionally killed Eric Smith and did so with both premeditation and deliberation. Your Honor, we will meet that burden. Evidence will show that the defendant blamed Eric Smith for the death of her mother. Your Honor, this was a crime of vengeance because right after the defendant's mother's funeral, Terry Edwards will tell you how she heard the defendant scream, "I'm going to kill him." And the evidence will show that's exactly what the defendant did. The defendant captured a deadly Mojave rattlesnake, removed its rattle so that it wouldn't make a sound so that she wouldn't get caught, and placed that snake in Eric Smith's mailbox with the intent to kill. Today you will hear testimony from witness Angel Russell, who was working the lines on Raptor Road on April 29th. Mr. Russell will tell you that he saw the defendant at the victim's mailbox, snake cage in hand, and less than 3 hours later, he saw Eric Smith get bit by a snake. The next morning, he found the victim dead in his front lawn. Now, Deputy Tony Garrett, the arresting officer in this case, will testify to the snake handling gloves, snake cage, and snake boots that were all found in the defendant's possession. And she will testify that the defendant sold these snake tools the same day that Eric Smith was found dead. Finally, Chief Medical Examiner Dr. Charlie Dunn will tell you that Eric Smith was killed by that snake bite and that bite alone. Your Honor, Eric Smith killed the defendant's mother, so the defendant killed Eric Smith. An eye for an eye, a life for a life. Because the defendant wanted vengeance, and that's exactly what she got. That is why, at the conclusion of evidence today, my co-counsel Natalia Betzler will ask that you return a verdict of guilty. Thank you, Your Honor.
Thank you. Does the defense wish to open at this time or reserve?
The defense wishes to proceed with their opening statements now, Your Honor.
Sergeant Wodo, please.
Good morning, Your Honor. Again, Mana Hashimoto on behalf of the defendant, Ms. Jamie Kobe. The desert is a deadly and dangerous place that can lead to devastating consequences. Burnsley County, home to Mr. Smith and Miss Kobe, is located in the middle of a desolate desert. This desert is home to many dangerous animals, including the most venomous snake in North America, the Mojave Rattlesnake. This snake is known to squeeze into tight spaces, and their bite, without proper medical attention, can be fatal. Today, the prosecution will tell you that Miss Kobe put a rattlesnake inside of Mr. Smith's mailbox. But Jamie Kobe did not seek vengeance or an eye for an eye. If you listen carefully to the evidence the prosecution offers, you will not hear any evidence that anyone saw Miss Kobe put a rattlesnake inside of Mr. Smith's mailbox. And the defense will offer evidence that shows that there was no crime committed because, Your Honor, the Mojave Rattlesnake crawled into Mr. Smith's mailbox on its own. On April 29th, Mr. Smith went to his mailbox, reached in, and was bitten by that Mojave rattlesnake. He died later, tragically. However, Your Honor, the deadly and dangerous desert is what claimed Mr. Smith's life, not Miss Jamie Kobe. You will hear today that Miss Kobe is an avid gardener and animal lover. She was Mr. Smith's tenant, and on the morning of April 29th, she went over to Mr. Smith's mailbox and deposited money for her rent, and nothing else. There is not a single witness today who saw Miss Kobe wrangle a dangerous and deadly Mojave rattlesnake and put it into Mr. Smith's mailbox. Today, the defense will call 4 witnesses to the stand. First, you will hear from Miss Jamie Kobe herself. She will tell you that she is a part of multiple animal rights organizations and that she has never harmed an animal. Second, you will hear from Miss Frances Yazzie, Miss Kobe's neighbor. Miss Yazzie will tell you that on April 28th, the day before Mr. Smith was bitten, Miss Kobe was calm, not angry. Third, you will hear from Miss Danny Emling, Miss Kobe's neighbor and Mr. Smith's tenant. Miss Emling will tell you that Miss Kobe always cooled off after any arguments she had with Mr. Smith. Miss Emling will also tell you that Miss Kobe has never used a creature to hurt another person. Finally, you will hear from Dr. Tyler Clay, the only snake expert in this case. Dr. Clay will tell you that it is common for snakes to crawl into mailboxes on their own. Furthermore, he will testify that he has seen cases in which snakes have crawled into mailboxes and have bit people when they tried to get their mail. Your Honor, the prosecution has charged the defendant with first-degree murder. This charge states that the prosecution must prove that the murder was willful, deliberate, and premeditated. The lesser charge of voluntary manslaughter states that the people must prove that the defendant killed someone because of a sudden quarrel or in the heat of passion. The prosecution has the burden of proof. They must prove beyond a reasonable doubt that Ms. Kobe is guilty. However, Your Honor, the prosecution will not meet the burden of proof today. At the conclusion of today's trial, you will see that the deadly and dangerous desert is what claimed Mr. Smith's life, not Miss Jamie Kobe. Accordingly, the defense asks that at the end of the trial, you find the defendant, Miss Jamie Kobe, not guilty on all charges. Thank you, Your Honor.
Thank you, Ms. Hashimoto. Case returns to the people for your case to commence. Your first witness, please.
Yes, Your Honor. The people call Deputy Sheriff Tony Garrett.
Tony Garrett, please state your name and spell your last name for the record.
Tony Garrett, Garrett.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
May I proceed, Your Honor?
You may.
Thank you. Good morning, Deputy.
Good morning.
Can you please introduce yourself to the court?
Yes, ma'am. My name is Tony Garrett. I've served as a deputy sheriff here in Burnsley for the past 20 years.
Deputy, did you know the victim, Eric Smith, in this case?
Yes, ma'am, I did.
How did you know him?
Over the years, I've responded personally to numerous calls from both Eric Smith as well as one of his tenants, Jamie Kobe.
Now, I'd like to direct your attention to April 30th, 2021. Did anything happen that morning?
Yes, ma'am.
What happened?
At 8:40 a.m., I responded to a call about a body. It had been found at 46601 Raptor Road, and that's where I found Eric Smith's body.
Now, did you conduct any interviews during your investigation?
Yes, ma'am, I did.
Who did you interview?
I interviewed a number of people for this investigation. One of the most important interviews that I conducted was with Angel Russell. He's the line worker who found the body.
What did you learn from Mr. Russell?
He spoke to me about having seen somebody at Mr. Smith's mailbox early the morning before with a wire cage, as well as having seen Mr. Smith be bitten by a snake.
Now, Deputy, I want to talk about any physical evidence you may have found. Did you ever search the victim's home?
Yes, ma'am, on the 30th.
What, if anything, did you find?
On the kitchen counter, I found envelopes. I identified them to be holding rent checks. None had the defendant's name on them.
Did you ever search the defendant's home?
I did.
What evidence did you find?
In the living room, I found books on venomous snakes and a tub of rattles. And in the garage, I found gloves, boots, and a large canvas bag.
Now, Deputy, did you ever interview the defendant?
Yes, ma'am, I did.
What did you learn from her?
Kobe told me that she had just recently sold her hunting knife and her animal trap.
Thank you, Deputy. Thank you, Your Honor. I have no further questions at this time.
Gross?
Yes, Your Honor. Good morning, Deputy Sheriff.
Good morning.
You responded to a call on April 30th at Eric Smith's house, right?
Yes, ma'am, that's correct.
And you said on direct this wasn't the first time you've been to Smith's house, right?
No, ma'am, it wasn't. I've been responding to calls from Smith as well as Kobe for going on 4 or 5 odd years now.
Yes, you responded to lots of these calls, but you believe them to be childish disputes, correct?
That's correct. Sometimes these calls can be frustrating. Of course, I kept responding to them. It's what I do.
Thank you. And you've also known Eric for about 20 years, your entire career, correct?
Yes, ma'am, that's correct. Smith is a sort of public figure in town. He's on the town council.
And in fact, last October, you even gave Eric Smith a police department camera, right?
Yes, ma'am, that's correct. In response to a call about a suspected break-in.
But you never found any evidence of a break-in, correct?
No, not that I found.
You just gave Eric Smith a camera. He never asked you for one?
Yes, ma'am, that's correct. I told Smith to use this camera to record a possible break-in to his home.
Thank you. You never gave Jamie Kobe a camera.
No, ma'am, I didn't. I hadn't been called to Kobe's home to such a substantial claim.
Thank you. Let's move on to your investigation. The mailbox. It's an important area, right?
Yes, ma'am, that's correct. I conducted a forensic fingerprint investigation on that mailbox.
Right? Mike, the snake Angel Russell showed you was found near this mailbox, right?
Yes, ma'am, that's correct.
And my client told you she put a rent check into that mailbox?
That's correct. That's what Miss Kobe told me.
You also dusted it for fingerprints, as you said?
I did. I lifted latent fingerprints off of that mailbox.
But in your investigation, you conducted a visual search. You only conducted a visual search of the ground near the mailbox, right?
Yes, ma'am, that's correct.
And
I didn't find anything out of the ordinary surrounding that ground.
Well, your search of the area near the mailbox was only cursory, correct?
Yes, ma'am, that's correct. It was a cursory visual search.
And in your statement, you only mention looking at Eric Smith's kitchen counter, correct?
I was in Mr. Smith's kitchen. I was in his home. That's correct.
You only mention, in your statement, you don't mention searching anywhere else in Eric Smith's home, correct?
No, ma'am. I only mentioned the relevant evidence that I found in Mr. Smith's home.
And you found 3 rent checks on the kitchen counter, correct?
No, ma'am. I found 3 rent envelopes.
With rent checks inside, right?
That's correct.
And my client told you that she paid her rent in cash. Is that correct?
Miss Kobe never specified in our interview if it was cash or check.
All right. Thank you. No further questions.
Redirect.
Yes, Your Honor. Now, Deputy, opposing counsel asked you about giving Eric Smith a security camera last October. Can you please explain to the why you gave that security camera to him?
Of course. I'd been responding to a substantial call about a possible break-in, and given the history of animosity that I had reviewed between the neighbors, Kobe and Smith, I deduced that this would be the best possible course of action pertaining to this certain situation.
They also asked you about your search of Eric Smith's house and how you found rent checks on the kitchen counter.
Objection, leading the witness.
Would you restate the question, please?
Deputy, opposing counsel asked you about your search of Eric Smith's home and finding rent checks on the kitchen counter. Did you ever find the defendants among those?
And your objection is that's leading?
Before, I believe that they just rephrased their question beforehand.
This question is allowed. There is no objection. Proceed.
No, ma'am, I didn't find Kobe's rent check, though she did tell me that she dropped it off, which I found odd.
Thank you, Deputy. Thank you, Your Honor. I have no further questions. May this witness please be excused?
Yes.
Thank you.
Your next witness, please.
Your Honor, at this time, the people call Angel Russell to the witness stand.
Angel Russell, please state your name and spell your last name for the record.
My name is Angel Russell, Russell.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Thank you.
Proceed.
Good morning, Mr. Russell.
Good morning.
What do you do for a living?
I'm a line worker in Bernsley County.
What do you do as a line worker?
As a line worker, I mostly deal with maintaining the lines around Bernsley. Just making sure the power stays on for everyone.
Did you know Eric Smith?
I knew Eric just from around town, but not personally.
Did you see Eric Smith on April 29th, 2021?
I did. On the 29th, I was working on the Raptor Road line when I saw Mr. Smith walk from his house up to a mailbox.
Did he open that mailbox?
He did. But when he reached inside,
In Your Honor, this witness is lapsing into narrative. I believe the question asked for yes or no answer.
Question has been asked and answered. Your objection sustained. Please proceed.
Yes, Your Honor. What happened when he opened that mailbox, Mr. Russell?
well, when he reached inside, he screamed. When he took his arm back out of the mailbox, it seemed like there was a snake hanging off of his wrist.
Mr. Russell, how did you react to this?
Well, I was still up on the pole when I saw this happen. So I climbed down and I ran over to Mr. Smith as fast as I could. When I got to him, he was on the ground and he seemed to be in a lot of pain.
Did Eric Smith say anything?
He did. Once he had shaken the snake from off of his wrist, he screamed, "Jamie."
Objection, Your Honor. Hearsay as to Jamie.
Your Honor, may be heard.
You may.
This statement falls under hearsay exception B, excited utterance.
Your Honor, may I be heard?
You may.
Thank you. On page 81, lines 36 to 40 of the mock trial packet, it states that 1, the excited statement must describe or explain the event, and 2, it must be made shortly after the event while the declarant is still under the excited state. It does not meet the first component of the excited utterance exception because the statement was made sometime after Smith was bitten, since Angel had to climb down from the pole and then run 100 feet to where Smith was and then back 100 feet to grab a breaker bar. Furthermore, Smith was also still not under the excited state since he was able to stand up. Furthermore, in the facts situation, it states that Smith then told Russell that Smith felt okay on page 11, lines 2 to 3. And the second component was not met because Jamie does not describe the event. It is simply someone's name, and in no way does it describe the event. It could be Eric Smith simply asking Jamie for help because they saw Jamie nearby.
Your Honor, may be heard.
You may.
Your Honor, as to the first component of this exception that opposing counsel mentioned, Your Honor, this statement was made while the declarant was in a state of excitement. Your Honor, pursuant to our stipulated rules of evidence, the statement may be made during or shortly after an exciting event. This statement was made shortly after Eric Smith was bit by the snake while he was still under the stress of excitement caused by the event. In addition, as to the second element that opposing counsel mentioned, this statement, Jamie, is Eric Smith's explanation for this exciting event, and it was made shortly after the event occurred. Your Honor, this statement reflects Eric Smith's explanation for the cause of the event, that he believed Jamie Kobe was responsible, and therefore this does fall under this hearsay exception.
Your Honor, may I please be heard one last time?
No, I'm going to rule on that. The objection is overruled and the answer may come in. Thank you.
Yes, Your Honor. Now, Mr. Russell, did you ever check on Mr. Smith after that day?
I did. The very next day, I went back to the Raptor Road line when I saw Mr. Smith laying face down in his front yard. He wasn't moving.
Mr. Russell, what did you do?
I ran over to Mr. Smith and I checked his pulse. I didn't find one. So I immediately called 911 and yelled out for help, but nobody responded to me.
Did you see anyone else at that mailbox on April 29th?
Yes, I did.
Who did you see?
I saw a person earlier that morning walk up to the mailbox holding two things.
What were they holding?
In one hand, they were holding some sort of bulky bag. And in the other hand, they were holding a wire metal cage. And they kept looking down at it.
Mr. Russell, who was this person?
It was Jamie Kobe.
Thank you, Mr. Russell, and thank you, Your Honor. I have no further questions at this time.
Cross-examine.
Yes, Your Honor. Good evening. Good morning, Mr. Russell. So on April 29th at 12 p.m., you recall seeing Mr. Smith at his mailbox, correct?
Yes, that's right.
And when Mr. Smith opened the mailbox, you noticed envelopes falling out of it, correct?
Yes, that's right. I noticed them on the ground as well when I ran over to
Right.
Mr. Smith.
Okay, thank you. And let's go back to the morning of April 29th. So you remember that Miss Kobe was near the mailbox, correct?
Yes, I do. She was standing right next to it.
And you specifically remember that Miss Kobe is wearing a long sleeve t-shirt, correct?
That's right, as well as a pair of jeans.
Right. And you gave a witness statement to the police, correct?
Yes, I did.
And in your testimony, you do not state that Miss Kobe was wearing snake handling gloves, correct?
No, at the time, I didn't notice anything like that.
And earlier, you mentioned that Miss Kobe was wearing jeans, correct? Right.
That's right.
And do you recall in your testimony whether Miss Kobe was wearing knee-high snake handling boots or snake boots? Apologies.
No, I didn't notice anything of the sort either.
But you did see Miss Kobe holding something akin to a gardening bag, correct?
That's right, in her left hand.
Right. But you didn't see Miss Kobe take anything out of the bag, correct?
No, I did not.
And you recall Miss Kobe was holding a wire cage, correct?
Yes, that's right.
Your Honor, at this time, I would like to turn your attention to Exhibit E on page 58. Mr. Russell, do you recognize this exhibit?
Yes, I do. It appears to be the cage I mentioned.
Is this a faithful and true, accurate depiction of the cage that you saw Miss Kobe holding?
Yes, it seems to be.
Your Honor, at this time, the defense requests that this exhibit be moved into the record.
Objection?
Yes, Your Honor, lack of foundation. Your Honor, may I be heard?
In what way?
Your Honor, this exhibit is labeled Kobe's Humane Animal Trap. There's a lack of foundation as to how this witness can verify that this cage, was in fact an animal trap.
Your Honor, may I please be heard?
You may.
Opposing counsel has already laid foundation to Miss Kobe holding this cage during direct examination. So I believe sufficient foundation has been laid.
Thank you. Objection overruled. You may answer.
May this exhibit be entered into the record?
Yes.
So would you say that this cage is see-through?
If you were standing close enough to it, I'm sure it would be.
Right. And you don't recall seeing anything inside of this cage, correct?
No, I do not. I don't remember if there's anything in it.
So you don't recall seeing a Mojave rattlesnake inside the cage, correct?
No, I was 100 feet away.
And in your testimony, you do not state whether Miss Kobe was holding a Mojave rattlesnake in her hands, correct?
No, I don't believe I ever testified to that.
And yes or no, in your testimony, you did not state whether Miss Kobe put a Mojave rattlesnake inside of Mr. Smith's mailbox, correct?
No, I don't believe I testified to that either.
Thank you. No further questions.
Redirect.
Briefly, Your Honor. Now, Mr. Russell, opposing counsel just asked you about what the defendant was holding when she walked up to the mailbox. Did you see the defendant holding an envelope of any kind?
No. All I noticed was the bulky bag, as well as the wire cage that I mentioned.
Thank you, Mr. Russell, and thank you, Your Honor. I have no further questions. May this witness please be excused.
Yes. The next witness, please.
Prior to calling our next witness, the people respectfully ask for a time check.
Time check, please.
The defense as well, please.
Your Honor, the people have 7 minutes and 48 seconds remaining on direct examination, and the defense has 4 minutes and 14 seconds remaining on cross-examination.
Thank you. Proceed.
The people call Terry Edwards to the stand.
Terry Edwards, please state your name and spell your last name for the record.
Terry Edwards, EDWARDS.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
Good morning, Miss Edwards.
Good morning.
Can you please tell the court a little bit about yourself?
Of course. My name is Terry Edwards. I'm actually a retired lawyer. I moved out to Burnsley around 10 years back, give or take. I've been loving every second of living out here.
Do you know the defendant, Jamie Kobe?
I do. I actually live down the road from Jamie, and I was there when her and her mom moved in.
And did you know the victim, Eric Smith?
I did. Eric was another one of my neighbors. I mean, we were friends.
Now, what, if any, interactions between these two did you witness?
You know, I've actually seen Jamie Kobe damage Eric's property, leave animal scat on Eric Smith's front porch, block Eric's driveway, things like that.
Now, I'd like to turn your attention to April 28th. Did you see Eric Smith that day?
I did see Eric at Jamie Kobe's mom's funeral. I saw the two of them get into a pretty heated argument.
And what, if anything, did you witness during that argument?
You know, I saw Jamie Kobe run out of the church where the funeral was taking place, and I heard yelling. Jamie yelled at Eric to leave and that he wasn't invited here.
Did Mr. Smith respond to that?
Eric just stood there and asked Jamie when she was going to move out.
Did Miss Kobe respond to that?
She did. I mean, Jamie screamed, "You killed my mom."
What, if anything, happened next, Miss Edwards?
Jamie just seemed to get angrier and angrier while Eric just laughed. I saw Jamie clench a fist, and I thought it would be best to separate them.
Now, did you hear Miss Kobe say anything else while you were at the funeral?
I did.
Can you please tell the court what that was?
At the reception, I overheard Jamie saying that this was it and that Jamie was finally going to do it.
Now, I'd like to talk to you about after the funeral. Did you see the defendant that evening?
Yes, I did. After the funeral, I mean, I felt like I had to check up on Jamie.
The witness is lapsing into a narrative.
Next question, please.
What happened when you saw Miss Kobe after the funeral?
You know, I tried to talk to Jamie, but before I could get a word out, I heard Jamie scream, "I'm going to kill him."
Thank you, Miss Edwards. Thank you, Your Honor. I have no further questions at this time.
Cross-examination.
Yes, Your Honor. Good morning, Miss Edwards.
Good morning.
You testified on direct that you and Mr. Smith are friends.
That's right, we are.
You didn't like Miss Kobe.
No, I mean, Jamie didn't finish the gardening work I paid her to do. We didn't get along.
You thought she was a pain.
No, I did.
You thought she was a real pain.
I wouldn't go that far. I mean, I just thought she was kind of a pain.
You gave a witness statement to the police.
I did.
And in that statement on page 40,
lines 8 on page 40. That's right. I thought Jamie could be a real pain. My mistake. It's a long day in Burnsley. You know how it is. It's hot out here.
Yeah, so you thought Miss Kobe could be a real pain.
Absolutely.
You live in the desert, correct?
I do. Love it here.
You've lived in the desert for 10 years.
That's right.
In the desert, snakes are active.
Objection, Your Honor. This question calls for improper witness opinion.
I'm sorry, improper, one moment.
Improper witness opinion.
Do you wish to respond, Ms. Gruber?
Yes, Your Honor. We have just established that this witness has lived in the desert for 10 years. And additionally, according to the mock trial case packet, page 77, lines 9 through 10, opinions based on a common experience are admissible. I believe that this witness has enough of a experience in the desert to give a proper lay witness opinion.
Your Honor, may I be heard?
You may.
Your Honor, pursuant to our stipulated rules of evidence, witnesses are allowed to opine when it, 1, is rationally based off their 5 senses, or 2, is helpful to a clear understanding of their testimony. Now, a common experience is something akin to the speed of a car or the look on someone's face. This is not permitted under our stipulated rules of evidence.
Your Honor, may I be heard?
No, the objection is overruled. You may continue.
In the desert, snakes are active.
That's right, around morning and dusk.
Right, snakes are more active in the early morning.
That's right.
You heard Miss Kobe say the words, "I am going to kill him," correct?
Absolutely. She screamed it.
She said this in her front garden.
I believe so.
She said this in front of you.
I think so. That's right.
And you didn't call the police?
No, I didn't. I'm not sure what I should have done.
You thought she was tired.
I did. That's why I told her to get some rest and that I would check up on her the next day.
Right. You suggested she get some rest.
Absolutely.
And you ignored her words.
I mean, I told Jamie to get some rest. I didn't fully ignore it, but I didn't call the police.
You ignored her words.
That's right, I did.
Thank you, Miss Edwards. No further questions, Your Honor.
Redirect.
Yes, Your Honor. Now, Ms. Edwards, opposing counsel asked you about snakes in Burnsley. Now, when are snakes most active?
Around early morning and dusk. That's why I found it odd that Jamie was gardening around that time.
Right. At what time did you see Jamie Kobe in her garden?
At dusk.
Thank you, Ms. Edwards. Thank you, Your Honor. I have no further questions. May this witness please be excused?
Yes, thank you. Your next witness, please.
Your Honor, before we call our last witness, the people request a time check.
The defense as well, please, Your Honor.
Madam Clerk.
Your Honor, the people have 4 minutes and 51 seconds on direct examination, and the defense has 1 minute and 59 seconds on cross-examination.
Thank you, Madam Clerk.
Ms. Cushing.
Yes, Your Honor. At this time, the people call Dr. Charlie Dunn to the witness stand.
Charlie Dunn. Please state your name and spell your last name for the record.
Charlie Dunn. D-U-N-N.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
May I proceed, Your Honor?
You may.
Thank you. Good morning, Dr. Dunn.
Good morning.
Could you please introduce yourself to the court?
Yes. Good morning, Your Honor. My name is Dr. Charlie Dunn. I'm a clinical and forensic toxicologist, and I've been serving as the chief medical examiner for Burnsley County for about 7 years now.
Thank you, doctor. You may examine.
Doctor, what is forensic toxicology?
Generally speaking, toxicology is the branch of science concerned with the study of poisons. So as a forensic toxicologist, I apply this knowledge to the investigation of crimes.
Could you explain your educational and professional background in this field?
Of course. I graduated medical school from at the University of Central California in 2005. I then did more postgraduate work, completing a residency specializing in clinical toxicology, and then I completed my fellowship in forensic toxicology.
How are you involved in today's case?
I was called to conduct an autopsy of Eric Smith's body and examine a snake I was informed had bitten him.
Doctor, can you please retrieve your copy of what has been pre-marked as Exhibit D?
Yes, I can.
Doctor, are you familiar with this image?
I am. This is a photo I took of the snake that bit Eric Smith.
Is it truthful and accurate?
Yes, it appears to be.
Your Honor, at this time, the people move to enter Exhibit D into evidence.
Objection?
No, Your Honor.
It's received. Proceed.
Doctor, can you describe this snake for the court?
I can. I identified it as a Mojave rattlesnake. I measured it to be 2 feet long and 2 inches wide at its widest point. I also noted, as you may be able to see, it's missing its rattle.
What can you tell us about the Mojave rattlesnake's venom?
The Mojave rattlesnake's venom contains a unique combination of hemotoxins, toxins that affect organs and blood, and neurotoxins, toxins that affect nerve tissue. The Mojave rattlesnake's venom is 16 times as potent than that of other rattlesnake species.
How do you believe this snake's venom affected Eric Smith?
Well, based on my autopsy of Eric Smith's body, I found epicardial hemorrhaging, which is essentially just bleeding around the heart, and acute tubular necrosis, a kidney disorder. Both of these conditions I typically see aggravated by or as a direct result of snake bites.
So, doctor, what do you believe to be the cause of death in this case?
I concluded that Eric Smith died from lethal envenomation. Essentially, the snake bite killed him. I believe that no intervening factors or pre-existing conditions would have changed the fact that the bite itself was fatal.
Thank you, Doctor, and thank you, Your Honor. I have no further questions at this time.
Ms. Hashimoto?
Yes, Your Honor. Dr. Dunn, you are a medical expert, correct?
Yes, I'm a medical examiner.
So you do not have a degree in herpetology, correct?
No, I do not.
And you examined the snake in today's case as you testified on direct, correct?
Yes, I did a visual examination.
And you determined that the snake that bit Mr. Smith was 2 inches wide, correct?
Yes, at its widest point.
Right. And it is your understanding that the mailbox opening was 1 3/4 inches wide, correct?
Around that wide. Yes.
Yes or no, snakes can squeeze into tight spaces.
Snakes are known to squeeze into tight spaces. That is true.
Yes or no, it is possible that this Mojave rattlesnake could have crawled into Mr. Smith's mailbox on its own.
As far as I know, it could have. I didn't make any conclusions about that.
And you have been a medical examiner since 2015, correct?
Yes, for about 7 years now.
And in your time as a medical examiner, you have only seen 1 death due to a venomous snake bite, correct?
Yes.
And you're aware that 7,000 to 8,000 people get bitten by snakes annually, correct?
Yes, and about 5 of those people die.
So it is relatively rare to die from a snake bite, correct?
Yes, but that's venomous snakes in general, not just the Mojave rattlesnake.
Mm-hmm. And Mr. Smith died around 3 a.m. to 6 a.m., correct?
Yes, based on the rigor mortis and the state of the body when I examined it.
Right, so he died 15 to 18 hours later after their initial snake bite, correct?
Yes.
30 seconds.
And you are aware that anti-venom is widely available, correct?
Yes.
Given the proper resources, do you believe that it would have been possible for Mr. Smith to have sought out medical attention given this large 15 to 18-hour time window?
Objection, Your Honor. Speculation.
Ms. Hashimoto, your reply?
Your Honor, this person is an expert witness, and this person has testified to extensive knowledge in the medical field. This is simply asking for a medical conclusion. And this person relies their theory on the fact that they state in their witness statement on page 32, lines 45 to 47. However, they would not change the fact that the bite itself was lethal without Smith having almost immediate access to antivenom. Furthermore, they have testified that antivenom is widely available. So I believe that it is a fair conclusion, a fair question to ask the witness.
Your Honor, may I be heard?
You may.
Opposing counsel asked this witness whether or not Eric Smith would have been able to receive medical attention. While this witness is a qualified expert in toxicology, they have no personal knowledge as to whether or not Eric Smith would have been able to receive medical attention given the time frame of this snake bite, and therefore this witness does not have the personal knowledge to answer opposing counsel's question.
Your Honor, may I please be heard?
Yes.
I was not asking if Mr. Smith had the resource, and furthermore, I prefaced my question with saying, given the proper resources, which states that this person does have the proper resources. And I'm simply asking whether Mr. Smith could have sought out proper medical attention given this large window. Thank you.
Yes. The objection will be sustained. I think that the facts laid by counsel in their respective questioning give fuel to argument if you choose to make it, but asking the doctor whether or not certain events might have happened or could have happened is pure speculation, and the objection is sustained.
You are aware that snake antivenom increases the chances of survival, correct?
Yes, and I believe Eric Smith would have needed almost immediate access to that antivenom to survive.
Thank you. No further questions, Your Honor.
Redirect?
Yes, Your Honor. Dr. Dunn, is it common for snakes to squeeze into mailboxes?
No, to my knowledge, it's actually rare. Snakes usually seek easily accessible and cooler spaces, such as under rocks or in crevices.
Doctor, was the mailbox in this case cooler than the surrounding environment?
It's estimated that the temperature inside the mailbox was 68 degrees Fahrenheit, the exact same temperature as the surrounding environment that day, so no.
Thank you, Doctor, and thank you, Your Honor. I have no further questions. May this witness be excused?
Yes. Further
Your Honor.
evidence? Go ahead, please.
Yes, Your Honor. At this time, the people rest.
People having rested, the case turns to the defense. Is the defense ready to proceed?
Yes, Your Honor. The defense would like to call Jamie Kobe to the stand.
Jamie Kobe.
Ms. Kobe?
Please state your name and spell your last name for the record.
Kobe, Cobey.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you. And for this court's convenience, this witness's statement can be found on pages 42 to 46 of the case packet.
Thank you.
Good morning, Ms. Kobe. Could you please introduce yourself to the court?
Good morning. My name is Jamie Kobe, and I've been a resident at 46603 Raptor Road for, gosh, it's got to be about 10 years now. I'm also a gardener specializing in xeriscaping.
What is xeriscaping?
Xeriscaping is a passion of mine as well as my career. It's a type of gardening in places with very little water in a way I feel I can give back to my community. Unfortunately, during the pandemic, it wasn't a reliable source of income.
How did you make money during the pandemic?
Our only income was my state unemployment check and my mother's state disability check.
I'm sorry, you said our income. Do you live with anybody else?
Well, me and my mother lived together until April 22nd when she passed away.
I'm so sorry to hear that. Do you mind telling me what happened?
Well, that morning I was out gardening, and Eric, when he shut off our power, my mother's oxygen tank failed. I didn't hear the alarm, and when I happened to go inside, she was in cardiac arrest. I tried to get her to the hospital, but it's 45 minutes away, and she didn't make it.
I'm so sorry for your loss, Miss Kobe. Was this the first time that Eric Smith shut off your power?
No, he's done it before.
When would he shut off your power in the past?
Well, under the eviction moratorium, Eric wasn't allowed to kick us out when I couldn't pay all my rent. I always tried to pay as much as I could, but it was the pandemic and money was tight. On the times I couldn't afford it, Eric would shut off our power.
So, would you say that you and Eric had a negative relationship then?
We definitely didn't have a positive one. It was generally childish, but never violent or vindictive. We never meant each other any harm.
Did you ever blame Eric for your mother's death?
You know, I can't blame him entirely. He wasn't my mother's primary caretaker. I was responsible for her. And the way I see it, blaming Eric wouldn't bring my mom back, so what would be the point?
How did you celebrate your mother's life?
I held a funeral for her about a week after her passing.
What happened at the funeral?
It generally went as well as a funeral can go. Lots of people came to pay their respects and remember her. But Eric also showed up uninvited and we got into an argument.
What did you and Eric argue about?
Eric, he said some hurtful things, like asking me when I was gonna move out. And in my grief, I told him some things I didn't mean, like telling him that he had killed my mom, but statement that I didn't mean and immediately regretted.
How did you calm down from your heightened emotions at the funeral?
Well, I went over to my friend Frances Yazzi's house, who's a dear friend, and she made me a cup of tea. We talked out the situation. She comforted me in my grief, and I went home feeling a lot calmer and supported.
What did you do when you got home?
I decided to do some gardening, and in my garden, I saw that some pests had eaten some of my succulents, so I yelled, "Ugh! I'm gonna kill them." But of course, it was just an expression.
Would you ever kill an animal, Miss Kobe?
Never, never, ever. I'm a lover of all living beings. I'm part of multiple animal rights activist groups and all—
Objection, Your Honor. Improper character evidence.
Do you wish to be heard, Ms. Marichak?
Yes, Your Honor. The defense can offer character evidence that speaks to the defendant's good character, and in this case, this evidence goes to their treatment of animals, and in this case, an animal is involved. We are simply rebutting the evidence that the prosecution brought in during their case that brought up incidents of my client leaving scat on Eric Smith's doorstep or leaving their car parked in the driveway.
Your Honor, may I be heard?
And you may.
Pursuant to our stipulated rules of evidence, character evidence for the defendant may only be offered through opinion testimony or evidence of reputation, not specific instances of conduct. By the defendant saying that they are part of several animal rights organizations, that they joined those organizations, the defense is attempting to offer a specific instance of conduct to prove the defendant's propensity for nonviolence against animals and living things. And this is not protected under the defendant's own character exception.
Your Honor, if I may be heard.
You may.
This also goes to the defendant's gardening practices, considering she has a humane animal trap. It is laying foundation for the possession of her humane animal trap, which she was seen using at the mailbox, and why she would have that in her possession.
The answer as given thus far will stand. The objection to its continuing is sustained. And to the defense, if I wish to ask her about a trap, ask her about a trap.
Thank you, Ms. Kobe. What kind of tools do you use when you garden?
Well, I have a humane animal trap. I also have the run-of-the-mill gardening tools that you would expect. And additionally, there are a lot of dangerous animals in the desert, like snakes and scorpions. So I have protective gloves and boots that are essential for handling those kind of animals.
Do you still have your tools?
Unfortunately, 2 days after my mother's funeral, I had to start the difficult process of selling some of my tools by putting flyers up around town. I was in debt from the pandemic and the additional funeral
Objection, Your Honor, non-responsive.
Sustained.
Motion to strike testimony after yes.
The testimony concerning the ancillary conduct in which she engaged, including the attendance at the funeral, is sustained. The motion to strike is granted. If you please proceed, Ms. Maranchek.
When did you sell your tools, Ms. Kobe?
I sold my tools 2 days after my mother's funeral.
And how did you go about selling these tools?
I went about selling them by putting a flyer up in town.
Ms. Kobe, did you put a snake into Eric Smith's mailbox?
I did no such thing. I would never weaponize a creature of the desert like that.
Objection, Your Honor, non-responsive.
The answer will stand at present. If you'll continue your interrogation, please.
Thank you. Did you ever want Eric Smith dead?
No. He may have been a bad landlord, but I didn't want to cause him any harm.
Thank you. No further questions at this time.
Ms. Betzler?
Yes, Your Honor. Good morning, Miss Kobe.
Good morning.
First, I'm so sorry for the loss of your mother, but I do have to ask you a couple questions about her death, and if you need a moment at any point in time, please let me know.
I understand, thank you.
Now, Miss Kobe, you believe that Eric Smith is responsible for your mother's death, right?
Partially.
But that's what you told him at her funeral, is it not?
I did say that to him, even if I didn't mean it.
Is that a yes to my question? You told Eric Smith that he killed your mother?
I did say that.
Now I want to talk about the morning after that funeral. You went to Eric Smith's mailbox, correct?
I did.
You claim you were at that mailbox to submit your rent, true?
I was paying $48 in cash, yes.
But Miss Kobe, you were holding an animal trap, is that correct?
I had some of my tools on hand, including the animal trap.
Now that animal trap, it was empty, true?
Yes.
So you brought that animal trap empty to your mailbox, correct?
Yes.
And then back to your...
Actually, to Eric's mailbox, not my mailbox.
My apologies. To Eric Smith's mailbox.
Yes.
And then back to your garden, correct?
Yes.
To be clear, you don't use this animal trap to transport rent, do you?
No, it's just some of my tools.
You use it to trap animals, correct?
I use it to humanely handle animals, yes.
This is a trap, true?
It is.
It holds animals, does it not?
Objection asked and answered.
We've moved to quibble. The objection is sustained, and if you'd change the course of questioning, please.
Yes, Your Honor. Now, you also use this animal trap to trap snakes, correct?
I do.
And the next day, after you were at that mailbox, you sold that trap, correct?
No, that's not true.
You put up the flyer to sell this trap. Is that correct?
That is true.
Now, Miss Kobe, I want to talk about your knowledge of snakes. You're very knowledgeable about Mojave Desert snakes, right?
Yes, I am.
You've spent a lot of time researching them, true?
I do.
You know how to spot them, correct?
Yes,
You know how to transport them, correct?
I do.
You know that it's possible to remove that snake's rattle. Is that true?
I mean, I guess someone could. It would
You
be
also,
insane.
my apologies. You also know that they're the most dangerous rattlesnake, correct?
Yes.
Thank you, Miss Kobe. Thank you, Your Honor. I have no further questions.
Ms. Marichek.
Brief redirect, Your Honor. Miss Kobe, why do you have these tools?
I have these tools as part of my career to protect myself and to protect my clients.
Thank you. No further questions. May this witness please return to virtual counsel table?
Yes.
Thank you.
Next witness, please.
The defense calls Miss Frances Yazzie to the stand.
Frances Yazzie. Please state your name and spell your last name for the record.
Frances Yazzie, Yazzie.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
May I inquire?
Good morning, Miss Yazzie. Would you please introduce yourself?
Good morning. My name is Frances Yazzie, and I live on Raptor Road with Jamie.
What do you do for a living?
I sell my art, which is mostly desert watercolors. I like to think I'm bringing the beauty out of a desolate place.
What is your relationship with Miss Kobe?
We're good friends. I found a kindred spirit in them during the pandemic. See, she also is a bringer of beauty.
What do you mean by that?
She's a xeriscape wonder and has been giving me free lessons. They make for a very patient teacher.
How often would you spend time with Miss Kobe?
During the pandemic, we had ourselves a little routine. Jamie would come by at around 4 p.m. and keep me company in exchange for a spot of tea.
What was it like spending time with Miss Kobe?
She's such a dear, spending all their time with two old ladies.
Two old ladies?
Myself and their mother. She used to spend all morning caring for their mom and would squeeze in their gardening whenever she can.
What happened the last time you saw Miss Kobe?
It was the day of her mother's funeral. She came by my house at around 4 p.m. They were grieving and decided to share that grief with me. And for that, I was honored.
What did you do?
I was there for her. I sat by them, made them their favorite tea. She's very quiet. Only sometimes would they say something about their mother, how hurt she felt.
What happened next?
She started seeming more like herself. By the time they left, we were laughing even. It all goes to show what a good cup of tea can do.
What did you laugh about?
She and Eric had a spat at the funeral. We were laughing about how absurd it was. They said, Eric is just being Eric.
Objection, Your Honor. Hearsay.
May I be heard, Your Honor?
You may.
This falls under the hearsay exception of state of mind. It goes to show that Miss Kobe was joking and didn't hold any ill will towards Eric Smith at the time.
Your Honor, may I be heard?
You may.
Your Honor, in order to fall under exception C, state of mind, the statement must show the specific state of mind, emotion, or physical condition of the declarant. Now, the statement Eric is just being Eric isn't specific enough to fall into one of these categories.
Now, your objection was hearsay, is that correct?
Yes, Your Honor.
What is the truth contained within that statement?
Well, Your Honor, the defense is bringing this in to try to show the state of mind of Jamie Kobe, but since it doesn't fall under the exception, it is inadmissible. Excuse me.
What do I learn from the phrase Eric is being Eric that contains inherent truth?
Well, Your Honor, the defense is alleging that Jamie believes that Eric was just being his normal self and that therefore Jamie was unfazed by the argument. However, it does not fall under the exception, and so it is inadmissible.
Ms. Kruger, you wish to reply to that?
I believe that it does fall under the state of mind exception, as it shows that Miss Kobe was joking around and lighthearted. And it is inherently true that Eric was being Eric.
Your Honor, may I be heard one more time?
Okay, one last time.
The inherent truth value is that Eric wasn't being a bad person or wasn't acting out of the ordinary, but because the specific statement, Eric is just being Eric, doesn't fall under one of the state of mind exceptions, it's inadmissible.
The objection is overruled. I will allow the evidence to stand. Move on, please.
Yes,
Did Miss Kobe mention any plans she had for after leaving your home?
Yes, they mentioned unwinding in their garden. Very typical Jamie behavior.
Objection, Your Honor, hearsay.
Your Honor,
I'm just not clear. What is hearsay about that statement?
The hearsay was that Jamie Kobe told this witness that they're going to go unwind in their garden.
They're going to
unwind in their garden.
May I be heard, Your Honor?
Yes.
This falls under the hearsay exception state of mind under a statement of intent.
I'll overrule the objection. You may go ahead. Thank you.
When she did leave your home, did her demeanor appear to be calm?
Yes, she'd returned to the darling Jamie I know and love, even tempered to their core, that one.
Thank you, Ms. Yazzie. No further questions at this time, Your Honor.
Cross-examination, Mr. Knowles.
Yes, Your Honor. Good morning, Ms. Yazzie.
Good morning.
Now, in one of your conversations with the defendant, she mentioned that her landlord would shut off her power. Is that correct?
Yes.
She told you that her landlord would do this to get her to move out. Is that right?
Sorry, you cut out for me. Could you repeat the question?
Of course. She told you that her landlord would cut off her power to get her to move out. Is that correct?
Yes.
And you were actually at the defendant's home on 2 occasions when this happened. Is that true?
Objection relevance?
Overruled. You may ask the question.
Now, in response to this, you told Ms. Kobe that that was probably illegal. Is that correct?
Yes, and I asked her to stop.
Right. But to the best of your knowledge, Ms. Yazzie, Ms. Kobe never called the police about that, did she?
To the best of my knowledge, I'm not sure. I don't think she did.
Right. She told you instead that she was handling it. Is that correct?
Yes, they did.
Thank you, Ms. Yazzie. Thank you, Your Honor. I have no further questions.
Redirect.
No, Your Honor. May this witness please be excused?
Yes. Witness may step down. Next witness, please.
Before we call the next witness, may we please have a time check on behalf of both sides?
Madam Clerk.
Of course. Your Honor, the defense has 6 minutes and 7 seconds remaining on direct examination, and the people have 6 minutes and 37 seconds remaining on cross-examination.
Thank you. You may proceed.
The defense calls Miss Danny Emling to the stand.
Danny Emling. Please state your name and spell your last name for the record.
Danny Emling, E-M-L-I-N-G.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
You may proceed.
Good morning, Miss Emling. Would you please introduce yourself?
Yes, good morning. My name is Danny Emling, and I am a proud resident of Burnsley County. I love the desert and my home on Raptor Road. To be honest, I'm a bit nervous to be in this courtroom today.
What is it like living in the desert?
Oh, it's everything I ever wanted. It's a dream, really. Well, once you get over the fact that all the little critters hiding in my garden might be out to get you.
What do you mean by that?
Well, the rattlers, for example. I'm no expert, but as someone who lives in the desert, I can see we get some pretty deadly ones around here. They're always lurking in the smallest spaces.
Who are your neighbors on Raptor Road?
I live across from Jamie and Eric. Jamie and I both rent from Eric.
How do you pay your rent?
Oh, every month when my rent is due, I drop off my check at Eric's mailbox.
Are you and Miss Kobe close?
Yeah, you could say so. Jamie and I go back as neighbors, and she came over once to work on my garden. It turned out beautifully. The kids sure got a gift.
What do you know about Miss Kobe's relationship with Mr. Smith?
To be honest, a lot more than I should. The two were always at it, and when Jamie wasn't calling the sheriff on Eric, she was over renting to me. After all, I'm Eric's tenant too.
After these rants, did Miss Kobe's demeanor appear to remain angry?
No, not at all. After Jamie would come over to rant to me, she would always leave with a seemingly level head and appear to have cooled down. That's the Jamie I know.
Have you ever witnessed Miss Kobe apologize to Mr. Smith?
Oh, many times. The kid's got too big a heart. Never letting Eric get to her like that, and never letting me.
Your Honor, non-responsive.
At this point, it's becoming non-responsive. The answer thus far given will stand. Your next question, please, counsel.
Would you say Miss Kobe is an animal lover?
Yeah, she is. She loves animals around here in Burnsley, and she respects the snakes we get around here too. She worships them, not weaponizes them.
Thank you, Miss Emling. No further questions at this time, Your Honor.
Prosecution inquiry?
Yes, Your Honor. Good morning, Miss Emling.
Good morning.
Now, you just stated on direct examination that you and Miss Kobe are close friends, correct?
Well, Jamie was my neighbor, and she came over to work on my garden. We got along.
You couldn't believe that Miss Kobe had been arrested for Eric Smith's murder, right?
Yes, could not believe it.
You witnessed multiple altercations between the defendant and Mr. Smith, correct?
Yes, they didn't have the best relationship, and I've heard much about it.
You witnessed several arguments between the defendant and Eric Smith in the few weeks leading up to Jamie's mother's funeral, true?
Yes, nothing new.
You attended that funeral on April 28th, correct?
I did. I was there.
While you were there, you heard the defendant yelling that Eric Smith should leave, true?
Yes.
You heard her yelling that Eric Smith was not invited, correct?
Yes.
That funeral was the last time you saw Eric Smith, wasn't it?
That was the last time, yes.
Thank you, Miss Emling. Thank you, Your Honor. I have no further questions.
Redirect, please.
No, Your Honor. May this witness please be excused?
Yes, if you'd step down, please, and your next witness, please.
Your Honor, before the defense calls their final witness, the defense respectfully requests a time check on behalf of both sides.
That request is granted. Madam Clerk?
Your Honor, the defense has 4 minutes and 2 seconds on direct examination, and the people have 5 minutes and 37 seconds on cross-examination.
Thank you.
Thank you.
The defense calls Dr. Tyler Clay to the stand.
Tyler Clay, please state your name and spell your last name for the record.
Tyler Clay, C-L-A-Y.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
You may examine.
Good evening, Dr. Clay. Can you please introduce yourself to the court?
Yes, good morning. My name is Dr. Tyler Clay. Currently, I'm the director of the Southland Zoological Museum here in California. In 2000, I earned my Bachelor of Science degree in biology from Central State University. Later on, I earned my master's and PhD degrees in biology, specializing in herpetology from the University of Central California. As a herpetologist, I'm an expert on the study of snakes.
How are you involved in today's case?
I examined Dr. Dunn's medical examiner's report on the death of Eric Smith, as well as the Mojave Rattlesnake specimen. I've also reviewed all relevant information corresponding to the case, including all witness statements and all exhibits.
Did you examine the rattlesnake that bit Mr. Smith?
Yes, I did.
What did you notice about the rattlesnake specimen?
I noticed that this particular specimen was missing its rattle.
In your expert opinion, is it possible for Mojave rattlesnakes to lose their rattles naturally?
Absolutely. Rattlesnakes losing their rattles is a natural, common occurrence. While they may look durable, rattles are actually very fragile and are made of keratin. For example, when snakes shed, they scrape against rocks or other hard surfaces. A snake's rattle can come off then.
Doctor, would it be dangerous to place a snake into a mailbox?
Yes, it's unlikely and dangerous. All snakes should be handled with great care. Dumping a rattler into an open mailbox, even with snake gloves, as Dr. Dunn has suggested, would be an extremely risky action for anybody, especially someone holding a trap, which we know based off Angel Russell's witness statement, Jamie Kobe had in hand the day she was at the mailbox.
Where was the rattlesnake? Where was Mr. Smith bitten?
Mr. Smith was bitten outside of his mailbox.
How common is it for snakes to be found in a dark place?
It's not uncommon, since snakes love dark spaces. I found snakes under barbecue appliances, under stacked wood piles, in between rock piles, and under car hoods, for example.
Is it common for snakes to be found in mailboxes?
Yes, in fact, I've even seen a couple of cases in which snakes have crawled into people's mailboxes and in some accounts even attacked the person out of self-defense.
Doctor, when are Mojave rattlesnakes most active?
Mojave rattlesnakes are most active from April to October, and according to Dr. Dunn's report, the incident took place on April 29th, exactly within the period when Mojave rattlesnakes are most active.
In your expert opinion, how could the Mojave rattlesnake have gotten into Mr. Smith's mailbox?
Based on my evaluation of the case and given the typical behavior of Mojave rattlesnakes, I believe it's highly unlikely that this particular snake was put into Eric Smith's mailbox. After reviewing the dimensions of both the snake and the mailbox, and considering that snakes are masterful at squeezing into tight spaces, it's completely within reason to assume that a snake of this size could have squeezed itself into Eric Smith's mailbox on its own accord.
Thank you. No further questions.
1 minute.
Yes,
Cross-examination, Your Honor.
please.
Now, Doctor, I want to talk to you about something that you just mentioned on direct examination. You mentioned that it's highly unlikely that the snake in this case was placed into the mailbox, correct?
Correct.
But to be clear, you didn't put that in your report, did you?
No.
Objection relevance?
Your Honor, may be heard.
You may.
Your Honor, this witness swore to include all relevant information in his report. The fact that he didn't include this extremely relevant piece of evidence in his witness statement is very relevant in our case today because it goes to this witness's credibility and the credibility of his conclusions.
Ms. Hashimoto?
Your Honor, there is a stipulation in the stipulations that states that both experts, including Dr. Clay, are qualified expert witnesses, so I do not see why it is necessary to determine the qualifications of this expert, given that I have laid foundation as to how this person is a herpetologist and thus a qualified expert in this case.
Objection is overruled. Thank you.
Now, Doctor, as you mentioned on direct, snakes have been found in a variety of hiding places, correct?
Correct.
They've been found under rock piles,
Yes.
under car hoods,
Yes.
under outdoor patio furniture.
Correct.
Now, Doctor, please retrieve your copy of what has been pre-marked as Exhibit B.
Yes, I had it.
Now, Doctor, this is a picture of Eric Smith's mailbox, correct?
Correct.
Is it truthful and accurate?
Yes.
Your Honor, at this time, the people moved to enter Exhibit B into evidence.
Pursuant to stipulation, it is received.
Yes, Your Honor. Now, Doctor, it's your opinion that the snake could have entered this mailbox through the top slot, correct?
Correct.
But in order to do this, the snake would have had to climb up this tree trunk, correct?
Correct.
It would have had to crawl over the side of the mailbox, true?
Correct.
And then it would have had to squeeze through the slot on the very top of the mailbox, correct?
Yes.
Doctor, this slot was 1 3/4 inches wide, correct?
Correct.
And at its widest point, the snake that bit Eric Smith was 2 inches wide, correct?
Yes.
Now, Doctor, when transporting venomous snakes, you'd recommend using specific equipment, correct?
Yes.
You'd recommend using an animal trap,
Correct.
snake-proof boots.
Yes.
You'd recommend using long bite-resistant gloves, correct?
Correct.
And Doctor, to your knowledge, the defendant owned all of these items, correct?
Correct. However, after I reviewed Angel Russell's witness statement, there are no witnesses.
Non-responsive.
I'm sorry, I had some oversound. Was there a comment, Ms. Cushy?
Yes, Your Honor, I objected non-responsive.
Your Honor, may be heard.
Let me back up a step. Two things happened at once and I became lost in the conversation. What is it you're objecting to, Ms. Cushy?
Non-responsive. I asked this witness whether or not the defendant owned these items. This expert said yes, and then continued to elaborate on his answer. He's being non-responsive.
Your Honor, may I please be heard?
Ms. Hashimoto, please.
The expert answered the question with a yes, and then is providing background for his explanation of why is providing background. He is a medical he's a snake expert, and background is important when forming conclusions and providing information relevant to today's case.
Your Honor, may be heard.
You may.
While the people do agree that background is important with experts, whether or not the defendant owned these items is a very clear yes or no question, and this does not require any background information or explanation from this witness.
I'll allow the answer. Go ahead, please.
So, doctor, to your knowledge, the defendant owned all of these snake handling tools, correct?
Yes, however, after reviewing Angel Russell's witness statement, there are no witnesses that can definitively identify that Jamie Kobe had either the boots or the gloves when she was at the mailbox.
Directing you back to my question, doctor, the defendant owned all of these items, correct?
Objection, Your Honor, asked and answered.
Your Honor may be heard.
No, the objection is overruled. You may answer. The answer will stand, I should say.
Yes, Your Honor. So, doctor, to be clear, the defendant owned all of these items.
Yes, at some point in time, the defendant owned all of these items.
Thank you, doctor. And thank you, Your Honor. I have no further questions for this witness.
Redirect examination.
Yes, Your Honor. Why do you believe that a snake could have gotten into this mailbox?
I believe that the snake could have gone into this mailbox for 3 key reasons. 1, snakes seek dark spaces. 2, snakes climb up elevated spaces. And 3, snakes are masterful at squeezing into tight spaces.
Thank you, Dr. Clay. No further questions. Your Honor, at this time, may the witness please be excused?
Yes.
And at this time, the defense rests.
Thank you. Before going into, I think this is appropriate at this point, before going into the closing comments of counsel, do the teams wish to confer and advise the court if there are any objections to the procedures that have been employed at this point? We'll take 1 minute for that.
The defense would like to waive this right, Your Honor.
Thank you. Prosecution?
No irregularities from the people, Your Honor.
Duly noted. We move on then to the closing statements, the opening argument actually by the prosecution. Prosecution's argument, please.
Yes, Your Honor. The defense is right. The desert is a deadly dangerous place, home to many species of venomous animals. We know that's true. You know who else knew that? The defendant. The defendant knew that Mojave rattlesnakes are the deadliest species in North America, that a single bite from this snake would kill. She knew how to capture them, knew how to transport them, knew how to handle them, knew how to remove their rattles, and Your Honor, that is exactly what she did on April 29th. She captured that snake, took it to Eric Smith's mailbox, and placed it inside with the intent to kill. The desert is a dangerous place, and the defendant knew that. She took advantage of it because she wanted vengeance for the death of her mother. An eye for an eye, a life for a life. Your Honor, it wasn't the desert that claimed Eric Smith's life, it was Jamie Kobe. The defense's case relies on the supposed reasonable doubt that their expert witness provides. But that expert witness was impeached on the witness stand today about whether a snake was placed in that mailbox. Your Honor, he fabricated conclusions because he had to lie, to cover up, because the defense's theory is unreasonable, and they know it. What you heard in trial today is first-degree murder, the unlawful killing of a human being with malice aforethought, the intent to kill, with premeditation and deliberation. But how? How do we know beyond a reasonable doubt that that's what happened? Because the person the defendant hated most, the person who killed her mother, died not a month, not a week, but the day after they fought, the day after she said, "I am going to kill him." And the defendant was at the victim's mailbox, snake trap in hand, 3 hours before the victim was killed by a snake missing its rattle, and then had rattlesnake rattles in her home that morning. And then the defendant sold that trap and the tools necessary to commit this crime the next day, the day the victim was pronounced dead. That is why the people have charged Jamie Kobe with first-degree murder and the alternative offense of voluntary manslaughter. Let's take those one at a time. In order to prove the defendant is guilty of first-degree murder, California Penal Code Section 187, the people first must prove that the defendant intended to kill. How do we know this is true? Because you heard from witness Terry Edwards that the defendant said, "This is it. I'm finally going to do it." I'm going to kill him. Your Honor, that is intent. Second, we must prove that the defendant's crime was premeditated. Well, she had rattlesnake rattles, snake boots, animal handling gloves, a snake cage, and snake cages in her possession because she removed that snake's rattles so it wouldn't make a sound in the mailbox. She wouldn't get caught. How do we know she did that? Because of that tub of rattles. Your Honor, this wasn't impulsive. This was planned carefully and thoughtfully. That is premeditation. That leads us to the third element. The defendant knew putting the snake in the mailbox would kill the victim. Today she told you she has researched Mojave rattlesnakes, knows how dangerous they are, knows how to capture them, knows what tools to use, not because she likes to garden on the side, but because she prepared. She planned. She knew exactly what would happen when that 2-foot-long venomous snake jumped out of the mailbox at the victim. Let's talk about that second charge, voluntary manslaughter, California Penal Code Section 192A. This means the defendant would have acted from emotion instead of rational judgment after provocation, such as the death of her mother.
2 minutes.
But the defendant cooled down with Frances Yazzie after that funeral. She caught the snake and waited over 12 hours before placing it in the mailbox. That's where we make the distinction between first-degree murder and voluntary manslaughter, because, Your Honor, in this case, the defendant's judgment overcame her emotion, not the other way around. Today, we presented evidence pointing to guilt, proving Jamie Kobe is guilty of first-degree murder, and the defense has told you that all of this evidence is just a series of coincidences. The defense wants you to believe it's just a coincidence, that the defendant's mother was killed by the victim a week before he himself was found dead, that the defendant was at the murder scene with a snake cage, that the rent she claimed she was paying was never found, that the defendant sold the tools she held at that mailbox the day the victim died, that the defendant shouted, "I'm going to kill him," the night before Eric Smith was killed. The defense wants you to believe that it was coincidence after coincidence after coincidence after coincidence, but Your Honor, at one point, it's not a coincidence. At this point, it's murder. In just a moment, the defense is going to get up here and talk to you about the burden of proof. They're going to tell you it's the highest burden in the judicial system. In order for you to convict Miss Kobe, the people must eliminate all reasonable doubt. The people have met that burden today. Even more, the defendant made your job easy for you because she already told you exactly who's guilty. This is it. I'm finally going to do it. I am going to kill him. Jamie Kobe is guilty, but don't take my word for it. Take hers. Thank you.
Thank you, Ms. Bessler. Comments by the defense, please.
Yes, Your Honor. Once again, Malia Marinchek on behalf of the defendant, Jamie Kobe. Both Jamie Kobe and Eric Smith were residents of the desolate desert that Bernsley County was a part of. They and every other Bernsley citizen knew the dangers that the desert contained, from the deadly creatures to the far distances one must travel for medical care. Your Honor, this case doesn't occur in the city or in the countryside. It occurs in the wild wasteland of the desert, where venomous animals are normal occurrences and when snakes are most active during the spring and summer months. Now, Jamie Kobe has lived in the desert for the past 10 years as her mother's primary caregiver. She has made a career as a gardener that brings life to the desert, not death. On April 22nd, when Eric Smith shut off Jamie's power, her mother's oxygen tank shut down. Her mother died on the 45-minute drive to the hospital. Your Honor, the desert played a hand in killing Jamie Kobe's mother, and the desert was what killed Eric Smith. Under CalCrim 224, the prosecution must prove their theory beyond a reasonable doubt, but there is not enough evidence to support their case. Miss Kobe is a gardener, both as a passion, but also as a career. For her, carrying the trap in her tool bag with her was similar to someone carrying a briefcase with them as she dropped off her rent. Now, because she is a gardener, part of the tools, the materials that she needs to be able to work, are protective gear. Long sleeve snake handling gloves, knee-high, bulky snake boots, these are key to protecting herself not just from snakes, but from other deadly animals, scorpions, fire ants. Now, the prosecution claims that Kobe carrying a wire humane animal trap with them to Eric Smith's mailbox is enough to prove that she put a snake into the mailbox. But today, the eyewitness, Angel Russell, told you that they did not see Jamie wearing any knee-high snake boots. They only saw jeans. They did not see Jamie wearing any long-sleeve snake gloves. They only saw a t-shirt. And lastly, the eyewitness, Angel Russell, who was able to properly identify the defendant, could not see a snake in a see-through wire cage. Dr. Clay just told us how unsafe it would be to handle a snake without the proper protective tools that include snake gloves, snake boots, gear that Angel Russell did not see my client wearing. Additionally, Dr. Clay told us that even with all of the proper protective tools, the act of getting a snake into a confined space such as a mailbox is incredibly dangerous. First and foremost, this case comes down to snake behavior. There was only one snake behavior expert witness, Dr. Tyler Clay. Dr. Clay told us that it is highly typical behavior for snakes to squeeze into tight spaces. And Dr. Dunn, the prosecution expert, agreed with this point today. In fact, Dr. Dunn went on to say that it was possible for the snake to have gotten into the mailbox on its own. Your Honor, that is reasonable doubt. It is important to remember that Eric Smith's mailbox had a 1 3/4 inch slot, and the snake examined by Dr. Clay was 2 inches at its widest point. With that small of a difference in size and it being within a snake's nature to squeeze into tight spaces, it's reasonable to believe that the snake got into the mailbox on its own. Additionally, the herpetologist told us that snakes love seeking out dark spaces, especially during the day. He has seen snakes hiding in mailboxes before. It is more reasonable to assume that in the desolate desert where snakes are active and common, that a snake got into the mailbox on its own. The prosecution cannot rule out the possibility or ignore the high probability that that was what happened on April 30th. Now let's go to the plan of premeditation. If Jamie Kobe's plan was so well thought out, why would she use a snake as a murder weapon? The prosecution talks about how the Mojave Rattlesnake is the most deadly, but Dr. Dunn has only seen 1 death from a snake bite in their entire 10-year career. Rattlesnake antivenom is easily accessible. Would using an animal with a low chance of death be a wise way to kill someone? And if she was planning a well-thought-out murder, why would she leave her fingerprints all over the mailbox, especially when she had protective gloves she could have used to both protect herself and hide her fingerprints?
30 seconds.
Let me remind you that Eric Smith is not the only person who uses that mailbox. All renters put their rent checks into that envelope. Would Jamie Kobe endanger their friends' lives and put them at risk? Your Honor, the prosecution has failed to meet the burden of proof. And due to the abundance of reasonable doubt, we ask that you find Jamie Kobe not guilty on all counts. Thank you.
Thank you, counsel. Rebuttal?
Yes, Your Honor. Eric Smith killed the defendant's mother. A week later, he was dead. The morning after her funeral, the defendant is at the victim's mailbox, snake cage in hand. 3 hours later, the victim is killed by a snake inside that mailbox. The next day, the day the police interviewed her, the defendant got rid of the evidence. Last thing, Your Honor, the defendant's own words. I am going to kill him. So what does that tell you, Your Honor? As the defense explained, when there are 2 reasonable interpretations of the evidence, you must adopt the one pointing to innocence. But what they didn't mention was the second part of Calcum 224, that if the interpretations of the evidence are unreasonable, you must by law reject them. Because the thing about reasonable doubt is that it must be reasonable. And the thing about the defense's case is that it isn't. The desert didn't kill Eric Smith. The defendant did. And she told you that herself. find the defendant guilty of first-degree murder. Thank you, Your Honor.
Thank you. And a final comment by the defense.
Yes, Your Honor. The prosecution has the burden of proof to prove that Jamie Kobe killed Eric Smith beyond a reasonable doubt. But the only evidence they have was that Angel Russell saw my client standing next to a mailbox. They brought up words that my client said at a funeral, but they were taken out of context. Terry Edwards overheard conversations in which my client said, "I'm going to do it." She never heard these conversations. Your Honor, the prosecution is looking for someone to blame. My client is grieving, not guilty. Your Honor, let's take a look at the supposed reasonable plan. Miss Kobe, after her mother's funeral, would go out and spend all night prowling, searching the desert, and finding a Mojave rattlesnake. And then, the next morning, without the proper protective tools and with an eyewitness 100 feet away, wrestle a snake into a confined space. Your Honor, that is unreasonable. And due to the abundance of reasonable doubt, we ask that you find Jamie Kobe not guilty.
Thank you. I'm not sure procedurally where we go here. I know I have two tasks remaining for me. Is this a time and if staff is here, is this a time that the scorers contemplate what they do, or is this a time for my comments and then we turn to the scorers? Some help here?
Sure, if you can have them, the students confer for the MVP right now while the scorers complete their score sheets, and if you can complete the tiebreaker and render your verdict after you allow the teams to announce the MVP recipients for each team.
Okay. My task now is to give them a time to do that, and I invite them to do so. Thereafter, I will render my verdict. And do I announce my tiebreaker, or do I withhold that until there's a need for a tiebreaker? Ms. Morales?
If you don't mind completing that online, I believe we emailed you that tiebreaker. If you can complete that at this time as well.
Okay.
And not share with the team.
Let me complete that task. And I think I'm pretty good at trials, but these procedures are less than at my talent point. Okay, have the respective teams selected the MVP at this point? I'll turn first to team 11 and your vote for MVP, please.
Yes, Your Honor. The defense would like to nominate Natalia Betzler for an amazing trial today.
Thank you. The people would like to nominate Adela Kellerman. You did a phenomenal job.
And I have one question on this. It's just something that I've been doing this for almost 40 years in mock trial. And the only thing you can absolutely predict in mock trial is that the defendant will be as disparate looking as possible from what the nasty defendant would likely appear to be. I'm always waiting for the left tackle off the football team to show up as the defendant, but it never happens. So anyway, my little aside on experiences. I Need I make any further comment with respect to MVP, or does it stop at that? Ms. Morales, I'm not doing well by you, but that's it.
You're fine. Yeah, so I want to also acknowledge that we have received all score sheets. So thank you so much. And then you can go ahead and proceed with the verdict.
Okay, and this is a really fascinating case. I've heard this case, I think this is the third or fourth time, and I helped write the problem. And the head-to-head here was delightful. As a practical matter, the character evidence offered concerning defendant, the nature of the hostility between them, and the factual issues concerning the circumstances of the homicide lead me to conclude that a jury, and I guess that's me at this point, would be hard-pressed to convict of murder. I won't say that the elements weren't proved, but I would have hesitation about the reflective aspect of premeditated murder. I think the evidence is clear that the defendant did it. And I think the evidence is reasonably clear to me that it may be toying with the concept of sudden quarrel or heat of passion to get me to a manslaughter. But I think that's what happened here. Jamie was angry, hurt, and firmly believed that that wicked defendant had killed her mother. And the snake sneaking into the box, getting into the slot, that doesn't bother me at all. The circumstances surrounding this just point, I think, unequivocally to defendant having committed the act. As to whether or not the requisite state of mind was there, there's two things that come into play. I think a jury hearing this case, as I said, would be hard-pressed under these facts and circumstances to ever return a verdict of murder, that most heinous of crimes. This was a pretty heinous course of conduct, but precipitated what I believe to have been the sincere belief by a defendant that, and one well-founded, that the victim killed her mother. And I think that the prosecution did an excellent job of getting to that. So my verdict is I find the defendant, I'm not sure if it's charged as a lesser included or as a substantive charge, but I do not find the defendant guilty of murder, but I do find the defendant guilty of manslaughter. And on that basis, that concludes the trial. Again, I turn to you, Ms. Morales. Is there anything I'm to say or do other than my editorial comments, or turn to my colleagues who were scoring and allow them a few comments before I offer mine?
Yes, at this time, I would like to ask Andrew to stop streaming, and then we'll open it up for the scorers to introduce themselves and start a quick